Welcome back to This Week in Louisiana Politics. I am joined in studio by Attorney General Liz Murrill. Thanks for coming on the show.
It's great to be with you, Fred.
Well, let's start with the redistricting case. There's a lot of background to this. We were just talking about this. Yep. We've already gotten to that. I want to talk to you about the re-arguments that are set to take place October 15th. What will your office be telling the courts?
So the court actually brought up an issue that was not raised in the early briefing of the case. So I think that's important because people wonder, why are we here? You know, why have we all changed kind of our positions? It's because there's an issue that the court asked us to brief. And as a defendant in the case, I wouldn't have raised that issue, but the plaintiffs ordinarily would have and didn't. And so the court has now said, well, we want you to brief and argue this issue anyway. That's very unusual for the court. Usually if a plaintiff waives an issue, it's done. You're sorry, too bad, you should have brought this up to us and didn't. But the court must be pretty hung up on the outcome and on the law, because this is an extraordinarily rare thing to happen where they schedule re-argument. It's only happened 4 times in the history of the United States Supreme Court, and this is the 4th. Yeah.
Well, and you're talking about the brief in the, what is a 67-page brief?
Yeah. One of many.
Yeah. Well, and tell me if this kind of encapsulates why you were defending the map and now you're not. In the brief, your office writes, yes, the state had defended the 2024 map because this court's current precedents permit it and 2 federal courts directed it, but we have never backed away from our conviction that race-based redistricting is unconstitutional.
That's right, and that's accurate. And I think that, you know, what I've tried to sort of explain is that you can't really tell the story of how we got here today to where we are without going all the way back to 1991, when the legislature drew a second majority minority district and it went into litigation. It was twice struck down by federal courts as a violation of the Equal Protection Clause. They went back and drew new maps. They have since then drawn, you know, pretty similar maps, although we lost a congressional seat in the meantime, and so we went from a 6-1 map to a 5-1 map. But those maps have been pre-cleared by the Justice Department over the years until we kind of got to where we are in 2021, when the legislature passed pretty much the same map that we had been using for a long time that had been pre-cleared, and it went into litigation on a new round of claims that it violated the Voting Rights Act. And so we said it doesn't. We don't think it does. It's been pre-cleared twice by the Justice Department, virtually identical map. And by the way, we've tried drawing a second majority minority map, and we can't do it without violating the Equal Protection Clause because of the way that you have to peel off black voters from municipalities all up and down our state. And, you know, not only do we find that to violate the Equal Protection Clause based on some of the court's jurisprudence, but we also think that it is kind of an offensive thing to have to do, to basically sort our voters by race and split communities in half to force them into a majority-minority district simply because the court had said, one judge on a federal court said, you violated the law. Now, how did we get there with only one judge? We got there because multiple judges after that and courts after that affirmed that judgment and said, go draw your map.
So it's your position that you want the courts out of the map drawing business? It
is, because the threat that was on our head was go draw your map, even though we are not going to allow you to have a trial on the merits in this case. We tried that, we argued that until we were blue in the face. And they just said, nope, go draw your map or we are going to draw it for you. And the problem with redistricting litigation, and we've seen this over and over again in every case that I've been involved in, and I think I've been involved in about 5 of them now, just in the last 8 years. All of them, the jurisprudence and the situation you find yourself in once you're in court is almost completely untethered to what happened in the legislature. So all the work that the legislature did, going around the state and taking testimony and talking to people about their community and understanding what the needs are of this community and how Shreveport is different from, say, Lafayette or Baton Rouge, all of that can be overridden by the fact finding of a single judge. And I just think that's wrong. I mean, it's put us in a really bad position, because once that ruling goes up on appeal, it's very hard to overturn it in federal courts. And so, you know, I think the Supreme Court agrees with us on that point. I mean, the decision came out last year in the Charleston County litigation, in that case, where Justice Alito said federal courts should not be in the business of drawing these maps.
Your re-argument's set for October 15th. What do you expect after that? What do you think is going to happen after that?
You know, I mean, we certainly hope that they will act very swiftly, because
but they don't have to.
Election dates. No, we have no control over when they issue the opinion. A lot of times they wait to issue the opinion until the dissenters get their opinion drafted and submitted. That would allow, in this case, the dissenters to potentially impact our deadlines. And so, you know, I think there will ultimately be a special session to address some of those deadlines, to try and give the court some breathing room to rule. Obviously, that's the purview of the legislature. But at I think, outside date that we would get an opinion would likely be the end of June.
Yeah, we'll have to ask the governor on the special session question for sure. I want to switch gears. I wanted to ask your opinion on the National Guard troops being requested to come to Louisiana.
Yeah, you know, I have not had anybody really tell me they don't think this is a good idea, frankly. I mean, I think we're used to having National Guard embedded with us when we respond to a crisis, particularly hurricanes. I mean, everybody's used to seeing the Guard out there handing out water and monitoring lines of people, kind of keeping crowd control and you know, helping to keep back chaos. So I don't think people are as worried about it or afraid of it, because we've been exposed to it. So, you know, we definitely need more boots on the ground. I mean, I was just at Crime Stoppers for the luncheon, and we talked a little bit there about how the Baton Rouge Police Department needs to recruit something like 160 officers. Well, New Orleans is about 800 officers short on there to be fully staffed there. And we know that law enforcement all over the state is really kind of struggling to keep fully staffed. So we can use the help. And
I've seen some of the people who are against it, they fall back on the resources argument, saying that we actually need more resources, we need more money for the officers, and we need more officers as well.
You know, I certainly support law enforcement, and I think we ought to pay them so that we can recruit them and pay them enough that it reflects the danger that they put themselves in every day. But that's not going to solve the problem, and it certainly isn't going to solve it right now, because it takes time to recruit and build and train a staff. So when you're talking about law enforcement, they have to go to an academy and train to be certified, and they have to understand what the law is, and they have to be able to train and understand how to use their weapon properly, and all that stuff really matters and is important. And I think that, you know, you can't just say we need more resources. That does not solve our problems.
All right. Attorney General Liz Murrill, thank you so much for coming on.
Thank you for having me.
Stay with us.